Just a warm welcome to everyone, all of our guests. It's so lovely to see some familiar names, not so much faces, in the audience, and also lovely to see new names in the audience. Welcome to everyone. We're really, really thankful that you've taken the time to join us as we tackle a topic that has really important implications for our workplaces and that really, has an impact on each one of us. So before we dive right into why you came, just a few administrative issues. So there will be a question and answer session at the end of our discussion. So if you would please keep yourselves muted during the presentations, and then we would love to hear from you. And we also realize that sometimes questions come up as someone is perhaps presenting something. So feel free to pop your questions into the chat as they come up throughout the presentation. I will be facilitating. I'll keep an eye on those. I'll make sure you get your airtime when we do get to the Q&A session. And then, I will kick us off. That's basically it. We'll do 50 minutes. We will be mindful of your time. We know it's lunchtime, so maybe you can still, use those final 10 minutes to grab a bite from the cafeteria or something. But yeah, we'll aim to finish by 10 to 1. And then please feel free to leave the call if we do end up going a bit over time. And then, to kick us off, so this is our very first PlutoLMS webinar. And we are thrilled to be kicking this new initiative off, and we're thrilled to have you guys join us. And how it actually came about, so the PlutoLMS team was introduced to Sarah a while ago, and we hit it off immediately. And we knew we wanted to collaborate in some kind of way. But then very interestingly, to kind of reinforce things, the PlutoLMS, a few of our team members spent a morning at an HR breakfast hosted by HR Networks in April, so in mid-April. And at this breakfast, a few of you will know, a few of you have attended, we met, some of you there. At this breakfast, every professional who joins gets an opportunity to introduce themselves and talk about an HR-related pain that they're experiencing. And we were quite taken aback by how strong the theme of employee misconduct and what a prevalent struggle that is in the workplace, how strong that theme came through. And making that connection with Sarah and having that theme come through so strongly on the morning of the HR breakfast really just reinforced the topic of this webinar and the need to host this and really get the information out there. So that is how this came about. We're super excited to be lining up new webinars for the future. So keep an eye on the space, and please also let us know if there are topics that you'd be interested in. We'd love to create value for the community. So in terms of HR, the HR topic at hand, and today's topic, proactively managing misconduct in the workplace. So it's sadly, as I mentioned, a really common issue in workplaces in South Africa, and things, from theft to fraud to harassment or disruptive behavior. These kinds of misconduct in the workplace can truly jeopardize trust, it can disrupt productivity, and it can put businesses at significant risk as well, especially when disciplinary measures are taken. That being said, we do have legislation that provides really great guidelines on how to actually approach this subject and how to manage misconduct. And so a good grasp on the legislation like the South African Labour Relations Act and the Basic Conditions of Employment Act can really help companies foster a safe, inclusive, and ethical workplace. And that is why we're here. That's why we brought in Sarah. That's what we'd like to learn about today and dive into. So Sarah Odendaal is our special guest today. She is a seasoned labor relations and HR management consultant. Sarah has over 12 years of diverse industry experience, including roles at Tokiso Dispute Settlement, LabourNet, and Gem HR. Today, Sarah practices in the Cape Town and Johannesburg areas as an independent labor relations and HR management consultant. So she's an expert in labor relations issues, from drafting contracts, policies, and warnings to facilitating mutual settlements, mediations, whistleblower investigations, and even chairing disciplinary hearings. And then also in the fields of HR management and organizational design, Sarah is really great at helping companies optimize their HR functions through strategic analysis and design. Additionally, as a speaker, we have Ian Fourie with us today. Ian Fourie is the founder and CEO of PlutoLMS. So Ian's journey, interestingly enough, began as a structural engineer. It's not what you'd expect. And as an engineer, he honed his problem-solving skills and attention to detail. But then, as a true embodiment of the power of being a lifelong learner, he made that switch. He upskilled and reskilled and repackaged his skills. And today, he has nearly a decade of experience in the e-learning industry. And he's deeply passionate about empowering organizations to unlock their employees' full potential through cutting-edge technologies like PlutoLMS. So just to set the agenda for today's meeting. So for the first 30 minutes, we'll have Sarah delve into the proactive management of misconduct in the workplace. She'll be exploring essential policies, procedures, and legislations that companies can implement to effectively manage and cultivate a positive workplace culture. And then Ian will take us through how, for the 10 minutes after that, he'll take us through how a learning management system can actually help organizations be more proactive in preventing and managing employee misconduct. And specifically, Ian will highlight how an LMS can streamline compliance training, making it more engaging, efficient, and aligned with your business objectives. Then, following the presentations, we'll have 10 minutes of Q&A. So like I said, please pop those questions in the chat as we go, and we'll facilitate that. And then, yeah, we'll take it from there. So without further ado, Sarah Odendaal, the floor is yours.
Thanks, Nika. Hi, everyone. It's so nice that you've all joined. Thanks for giving up your lunch break. I hope you've got some snacks while you join this webinar. Yeah, thanks for the intro. People always ask, you know, do you really enjoy what you do? Dealing with misconduct every day and dealing with grievances. And I'm always like, yes, I love it. And they're like, are you normal? What is wrong with you? But I think the passion that I have for this industry, and I'm sure the HR professionals who've joined, I've seen some of you that I've worked with a lot, know that no day is ever the same. So you might think you know the Labor Relations Act or you've dealt with this case before, but because we're people, all people are different, people are dynamic, there's always, you know, something that you learn every single day. So I think I'm going to get started. First thing, I think we all are aware that we live in South Africa, and South African labor law is one of the, I'd say, most interesting and most stringent labor laws that we have. So I'm very glad that I see, 29 of you have joined this webinar because you want to actually understand and be proactive in dealing with labor law, labor relations, and misconduct. So thanks for joining. I think to start off with, I want to go back to the basics of the employment relationship. So often when there's issues in the workplace, it actually all comes back to this point. So throughout the next 20 minutes or so, just have this image in mind that you've got your employer, you've got your employee. An employee is hired to actually provide services to their employer. And in exchange or in return for those services, the employee then gets remunerated. So you see where the reciprocal relationship lies here, that circle effect. The tension then comes in. And again, I always say I'm not a negative person. I always just say the facts of things. So don't think I'm negative, but often the tension lies in that you have an employee that wants to maybe work less for more money, and you have an employer that wants the employee to work more for less money. So do you see where this tension kind of stems from? So keep this in mind, keep the tension in play. Keep the tension and this reciprocal relationship in your mind as we go through it. The first step in being proactive with labor relations and managing misconduct is knowing the South African legislation. So again, we've heard of these things. We've heard of these laws, we've heard of these acts, but make sure that as an employer, you actually know what they are about. Often an employee will ask you something and you're overwhelmed, you don't know. It's most likely is going to be in one of these acts. The acts obviously don't provide for everything. I actually had a colleague, I see she's on the webinar, but she sent me something on Instagram as a joke. And she said the Instagram was basically like employee hacks. And this employee, it says, if you want to, let's say you have a deadline and you're not going to reach it, there's this app you can download that basically encrypts the file to make it unreadable for your boss, so that you then have extra time to reach the deadline. Okay, anyways, don't take that as a tip, but someone sent it to me as a funny thing. And again, the act doesn't tell us everything. I wish we could have a guideline for every scenario, but it does give us, a route to follow. So the first act is the Basic Conditions of Employment Act. I actually have it right here. I don't know if you can see in the screen, my little handbook. Basic Conditions of Employment Act, this speaks to any term and condition of employment. So your meal times, your leave, your maternity leave, your remuneration, anything to do with terms and conditions. The next thing is the Labor Relations Act. That explains all the types of fair labor practices that we need to actually follow. Occupational Health and Safety Act. I don't have a copy of that act, but very important to make sure that you have health and safety practices in place. Remember, as the employer, you are actually responsible for your employees' health and safety. And then the fourth one is the Employment Equity Act, which ensures that there is equity within the workplace and the disadvantages of the past are actually redressed, and we're looking out for them now. So with these 4 acts, please make sure it actually is a requirement, or we can still go back, but to have the posters on or available in your offices. So you can order these online. I think LexisNexis is also selling them. There are also a lot of companies that give them for free. So please just reach out and I can point you in the right direction. And you need to have these actually on show for your employees. One of my clients actually had a Department of Labor inspection. Everything was fine. The only thing the inspector said was, your posters need to be at eye level. That was all they could fault, because the posters were a bit lower. Anyways, I don't know if he was having a bad day or anything, but that was their feedback. So always have these on hand. Have the books. You can order them from Juta, or even the PDF version you can download from the Department of Labor website, or I can even just email them to you. Okay, next. So those are legislative. Make sure you're aware of that. Second thing to be proactive in the workplace is to ensure that your employees have a contract of employment. Again, it seems obvious, but it's not always the case. So the employment contract, there are a few names for it: contract of employment, letter of employment, employment contract, letter of appointment. It describes the relationship and the agreement between the employer and the employee. Legally, it doesn't have to be written. So you could verbally agree to things, but I think even if, as I'm saying it, it is just not a good idea, because if you don't have it written down, it leaves room for ambiguity. There's more room to have disputes because it's not clear cut. So make sure in your contracts that it's clear, there's clear language, and it incorporates the terms and conditions of that employment relationship. I just want to stop on the clear language part. Again, it seems obvious, but make sure that the contract actually makes sense. There's so many times that an employee will get a contract and then they go to HR and they say, what does this, 10-page clause mean? HR is kind of, I'll let you know, on ChatGPT, trying to understand it. So make sure that it's clear and it's unambiguous, so it's clear cut for everyone. Okay, so we've gone through the legislation, contracts. Next thing, to be proactive, to avoid misconduct or be proactive for misconduct, is fair workplace rules. So every workplace does have rules for its day-to-day operations. Obviously, the rules, you're going to get standard ones, but you're also going to have rules that are actually incorporated or depend on the company. So that's why it's so important to have these in your contract of employment. So a good example would be, let's say a company shuts down over December. You get 15 leave days, And this company says that when we shut down for 7 days in December, you have to use 7 of those 15 leave days and for that annual leave. So that would be applicable to that company, whereas another company might be a call center that won't shut down. Or, it might be the 7 days are over and above your 15 days. Things like that, the intricacies of the day-to-day is important to include in the contract. And important to note is that employers don't actually need to negotiate the rules that they put in place. So yes, you can consult with your employees and that, but remember that the employer has the prerogative to actually set the rules. So that also goes to your performance, which we're not going to cover today. Hopefully we'll have another webinar and we can talk about performance. That's a whole nother journey. But performance is, so like performance, an employer has the prerogative to actually set that standard. An employee can't say, well, I think I performed well today, and the employer disagrees. The employer would have to actually set that standard. So very important to have fair workplace rules in place and make sure that it is clear and that the employees are aware of them. Okay, when it comes to enforcing the rules, you need to ensure these 3 things with the rules. So the rule is valid and reasonable. So an example of that would be, we couldn't have a rule that says, I don't know, you only get 5 leave days a year, because that is invalid, because legally we're entitled to 15 working days per year. So that you wouldn't be able to be enforced. Is the rule reasonable? And let's say we put a rule in place that says you have to work 18 hours a day, okay, or 20 hours a day. Again, unreasonable. The second one is the employee is aware of the rule. What's also notable on this is that the employee can also be reasonably expected to be aware of the rule. So an example of this is, let's say you've got your policies and you don't put in, you don't put in a clause that says do not assault your fellow employee, okay? If you then assault your employee, you can't say, oh, I didn't know, sorry, Sarah, I didn't actually know that I wasn't meant to, because you should reasonably be expected to be aware that you should not assault your employee, your fellow colleague. Okay, and then the third one is the rules applied consistently. It really doesn't help if, we see this a lot, one employee, maybe a manager's annoyed with them, or they're fed up, then this employee then gets the written warning, whereas it's happened a million times before to other staff members and they weren't, there was no punishment for it. So make sure it is consistently applied. Excuse me. Again, we recommend that it should be in writing, and that goes on to our next proactive approach, is having HR policies. Again, like I said in the beginning, when I introduce myself, people always ask, how do you find this fun? You must see when I go to clients and start the policy implementation, and the staff just look at me and they're like, why do we have to go through these? But it's so vital that both your employees and your employer knows their rights, so that no one can take advantage of anything. And again, it's so that the Labour Relations Act comes into play. There's fair disciplinary processes in place. So these are the best practice policies. I'm going to quickly just touch on each one, what they're about. So the first one is the disciplinary code. This explains all the things I guess you shouldn't do. So it explains that if you're going to, I don't know, take a nap and you, the receptionist, and when guests walk in, you're having a sleep, then you will get a first written warning. Okay, if you're a security guard and you take a nap, you most likely will be dismissed, because we know it can happen if you're sleeping on duty as a security guard. So it would set out things like suspension, processes to follow. What happens if, for example, an employee's arrested and they can't be at work? Can I charge them for that? But they've actually been arrested outside of the workplace. So this explains all your details of discipline in the workplace. The next one is the grievance policy and the grievance form. This gives employees an opportunity to actually lodge grievances. Very, very, I feel like everything I say is very important, but this is important because employees need to have a place to actually lodge grievances. And again, there's no grievance too big or too small. If it's affecting an employee, they're at work 9 hours a day, take it seriously. And there are 2 ways to handle it, formally or informally. So it depends on what the grievance is. I'm sure a lot of my colleagues in this webinar will know a big grievance we've often had is the aircon temperature. You wouldn't think, but I promise you this is like the biggest biggest issue in the workplace, not the biggest, but one of the big ones. So it's affecting them. They sign a grievance, they fill out the grievance form, and then you would then bring in someone to actually mediate and try resolve it. The next one is the harassment policy. This includes sexual harassment, all your different types of harassment, and explains the procedure that you must follow if there is any form of harassment in the workplace. HIV/AIDS, it explains that no one would be discriminated for their status. And also you'd never be asked to disclose your status. Retirement, quite standard. And then smoking, I'd also suggest with the smoking policy, just to update it to start include vaping. I know vaping is quite a big thing now. People also vaping in the office. I've seen some companies that allow it, others don't. So just make sure you're clear on that. With vaping, I mean, it is a form of smoking, so it would most likely then fall under your smoking policy, but just make sure, again, it's clear, so there's no ambiguity. And then the poppy policy, our favorite, making sure that our personal information is secured. And then health and safety, making sure your employees are safe. Employment equity, this will be applicable if you've got more than 50 employees. Then absenteeism and absconsion, this explains the process to follow. Again, it's important, like if an employee has absconded, which means they've just left, you don't know where they are, you need to actually have that process in place because it's different to a dismissal. You wouldn't dismiss someone for absconsion. Absconsion and employees actually unilaterally breach their own contract of employment by leaving, not telling you. So that would be a different process. Then email and internet, make sure that you covered there. Leave, again, going to be very interesting to see what happens with the case of maternity leave. I'm sure some of you have heard about that. But again, to make sure you update your policies. And then social media, just to explain that anything you put on social media is public. So when you call in sick and then forget that you've updated your Instagram status and your WhatsApp status to say that you're actually at, I don't know, the cricket, that was one case I had, everyone can see it. Okay, so just to reiterate that, and then the recruitment policy is how to actually hire staff, make sure it's fair, make sure it's equitable. So quite a lot to take in, but very crucial to have in place. Okay, the next thing is to, following on from the policies, ensuring that we are proactive, is ensuring a fair disciplinary framework. So before the Labour Relations Act, there was no cause to dismiss someone. You could just, like you see in the movies, you're fired with actually no reason. Now, thankfully, we've got the Labour Relations Act. And the Labour Relations Act actually speaks to procedures. It speaks to fairness. It now also highlights something called progressive discipline. So what progressive discipline means is it says don't just take a punitive approach straight away. If you can, try and apply progressive discipline, unless it's something extremely serious. And the Act actually speaks of dishonesty as being dismissible for first offence. And of course, all the other things like your assault and I don't need to mention all of them. What's also required is actually how you draft your disciplinary charges if there are any issues of misconduct. And just before we go into that, I just want to make sure you're in the right mindset for anything that actually comes up in the workplace. So the easiest way I can describe this is actually, when I give training, this is like a 30-minute discussion, but I'm going to try just highlight it in 1 minute. If you see those 3 columns, misconduct, incapacity, and operational requirements, those are the 3 main headings or main categories of a way that an employee could be dismissed in the workplace. That sounds harsh, but it's the easiest way to actually describe what I'm explaining. There's misconduct, which we're discussing today. This we say is the fault of the employee. So the employee is aware, or it is their own fault that this misconduct has taken place. The way you deal with it is through disciplinary procedures. So that's like your warnings, which we'll go into now, your hearings. Incapacity, make sure that you follow a separate process for incapacity. Incapacity are things like your poor work performance, ill health. There's something called legal incapacity. So that's if, for example, I'm hired as the driver and my driver's license expires. I legally cannot work at that point. And that's when we say is no fault of the employee. Okay, the driver's license, I feel like you should have been organized, but the rest would be no fault because it's ill health, it's poor performance. And there we say, try and assist the employee, try help the employee. Again, if you last resort would be dismissal. And the third one is operational requirements, always the most terrible things, because it is your retrenchments. And again, it's not the employee's fault, and that would be a consultation procedure. So just make sure in any situation that you handle, you're in the right column or you're in the right lane, because your process will differ for each one. Okay, let's move on to the next one. I want to give an example of a type of charge. So I did speak about drafting correct charges. You can see I've been watching a lot of Survivor, my favorite show. That's why I just put Jeff Probst there as our example. But you can see that this is a good example of a charge with sufficient particularity. So insubordination, in that you failed to follow lawful and reasonable instruction. So it gives the title of the charge. What are you being charged with as an employee? Insubordination. And why are you being charged with it? You failed to follow lawful and reasonable instruction. And then you explain the instruction, whereby Jeff, who is your manager, gave you an instruction on the 1st of April to submit your report, which you actually did not do. So it's clear cut. I'm not, as an employee, getting like, what is this referring to? I've literally seen a charge, and I'm sure my colleagues will agree, in this webinar, where it says insubordination. That's all it says. So please attend a hearing for insubordination. And the employee says, okay, well, trying to think of all those times. So you have to have details of the charge. Okay, let's go to the next one. Okay, and then just to close off on the disciplinary processes, they're different sanctions. So going back, we said that progressive discipline is always the first approach, unless it's too serious. You get your sanctions, it's called sanctions short of dismissal. So this is when, again, you don't want dismissal, you want dismissal to be the last resort. So let's say there is an issue of, let's say, negligence. An employee's being negligent, they didn't, I don't know, they submitted an invoice, but it was incorrect to a client, something like that. Then you would refer to your disciplinary code and see what does it recommend? Is it a verbal warning, written warning, final written warning, or potentially a demotion? But with your final written warnings, demotions, dismissal, you would always need to have a disciplinary hearing. And Nico will actually send that workbook on how to prepare for a hearing. Again, touch wood, I hope none of you experience this anytime soon. But with all of the sanctions short of dismissal, it would depend on the company and what your disciplinary code says. Because again, all companies are different. And just a note on what general warnings are. General warnings are, it's like a group warning. So you've all been late for the last 3 weeks. I'm getting tired of this. The next person who's late, I'm drawing a line in the sand. You now will get a warning. So that's a general warning. And then dismissal, the code of good practice. So that's it's called Schedule 8 at the back of the Labor Relations Act. If you've got the book with you, it's at the back. And it just says it is the last resort. But again, if it's serious, then dismissal could be a first offense. Okay, and then just to close off, going back to the Labor Relations Act, I feel like a broken record. Oh no, you can go to the next one actually. But we need to have procedural fairness, which makes sure the actual process is correct. And you need to have something called substantive fairness. So a good example of this would be, I chaired a poor work performance, which is a form of incapacity. And during that process, we realized the reason the employee was not performing was actually due to an addiction, which now, if you go into those 3 columns, that actually goes into an incapacity due to ill health. So now you need to make sure you're in the correct lane. Where are we jumping? Is it a performance issue? Is it an ill health issue? Or is it a misconduct issue? So you always need to make sure you're following the right procedure and the reasons or the why for what you're doing is correct. So this is the checklist for procedural fairness. So if there is misconduct, was there prior investigation? There's nothing worse, and I promise you it has happened more than once. I'll be called to chair a hearing. I sit down and I say, you've actually been charged for sick leave for, I don't know, a week with no medical certificate. Your leave policy says you have to bring a medical certificate, and you've been sick for 5 days and with no proof. And then the employee says, no, here it is. And then everyone kind of sits around the table, why are you there? So make sure you've done an investigation. Another investigation where an employee claimed she was sick due to a death in the family. It was her mom. And then the company called the number she'd actually given for the mom, and then the mom answered. So that was a fraudulent claim. So again, do your investigation before you go right ahead with the actual hearing or the warning. Then the next thing is who actually chaired the hearing. Were they neutral? It doesn't help if you get someone there who's actually been briefed on the case. They've been told they need to dismiss the employee. That doesn't help. It has to be objective. The second was the notice to attend, notice to attend given. So that actually is a notice that says, this is your charge. This is when the hearing is. This is what you need to prepare. These are your rights. And also, was the employee given enough notice? Again, your disciplinary code would say how many days notice you give. The standard is usually about 48 hours. But again, if it's, let's say, a fraud case with files with this much, you're going to need a bit more time. Did the employee have time to prepare? Were they informed of their rights? Were they able to actually state their case? So did the chairperson listen to this employee? Did they have the right to an interpreter? And were they actually informed of the outcome of the hearing and also of their right to refer it? So every employee does have the right to refer to the CCMA or a bargaining council. A bargaining council is if, let's say, you're governed by a certain sector. So yeah, so you would then be referred to the bargaining council instead of the CCMA. And then secondly is the substantive fairness. So this is making sure the actual reason is fair. So was there a rule? Did it exist? Was it reasonable? Was the employee aware? Did the employee actually breach the rule? And the rule has it been consistently applied? So it's just reiterating the rules that we discussed in the beginning. Okay, and then just to close off, the proactive approaches. Make sure you understand the legislation. So let me know if you want the PDF acts that I legally downloaded from the Department of Labor. I'll just note that. Then the employment contract, making sure that's in place, making sure it's clear, concise, and the employee actually understands it, that they're fair workplace rules that are valid and reasonable, they're consistent, and the employee is aware of them. Policies and procedures, make sure they are in place and the employee is aware, and then having the fair disciplinary framework.
Thank you so much, Sarah. Thank you for sharing some really insightful processes and practical steps that workplaces can take to improve fairness and manage employee misconduct in a more proactive way. And so we'll segue into how PlutoLMS or a learning management system in general can actually aid in this approach as well. And so Ian, I'll hand over to you.
Awesome. Great. Thanks, Nika. Sarah, thank you. That was really, really insightful. We'll definitely loop you back in when we talk about performance for the next webinar. So thank you so much for that. One comment, most of my employees are taller than me, so the eye-level posters are a little bit tough for me to read. Anyway, awesome. So I'd like to delve into how PlutoLMS can enhance your compliance training initiatives, making them more effective, streamlined, and aligned with your business objectives. So a corporate learning management system is really just a software application that is designed to deliver, monitor, and manage employee training. So in particular, when it comes to compliance training, PlutoLMS provides you with a centralized platform where you can house all of your training materials, track employee progress, and ensure that everyone is up to date with the latest regulations and company policies. So with PlutoLMS, you can easily create and manage both industry compliance and internal compliance training courses. So from an industry compliance perspective, these might include things like occupational health and safety, cybersecurity, diversity and inclusion. For internal compliance, these could cover areas such as code of conduct, anti-harassment, and data management. Now, let's talk about the tangible benefits of using PlutoLMS for your compliance training. Starting off at number one, definitely when it comes to training, you want to centralize everything. So you want centralized training materials. So PlutoLMS allows you to upload, store, and update policies, procedures, and training materials in one centralized location. Ultimately, this just ensures that all employees have access to the same up-to-date information, no matter where they're located. Additionally, PlutoLMS features strong security protocols, including secure user access, helping organizations manage sensitive training materials and mitigate risks. So having a central repository for all training materials really simplifies the management and dissemination of critical information. This reduces the risk that misinformation or outdated practices will be circulated within the organization. Beyond convenience and consistency, of course, access to critical policies and procedures empowers employees to understand what is expected of them, how to conduct themselves appropriately, of course, and where to seek guidance if they have questions or concern. So this clarity can help prevent unintentional violations of company policies and reduce the likelihood of misunderstandings that could lead to disciplinary actions, as Sarah has mentioned. So for employers, having documented up-to-date policies and training records can really serve as a crucial evidence, really, of due diligence. So in the event of an employee misconduct or, let's say, a compliance breach, this potentially mitigates legal risks and liabilities. Great, next slide. Number 2, monitoring and reporting. So PlutoLMS really allows you to monitor employee completion of training courses in real time. You can track individual course completions, time to completion, drop-off rates, and levels of proficiency. This valuable data enables you to identify employees who may need additional support or interventions, ensuring that everyone is on track with their compliance training. But the benefits extend beyond just tracking completion rates. The detailed completion data collected and stored by PlutoLMS can serve as a valuable evidence in disciplinary proceedings against offending employees. Should you find yourself in a situation, let's say, where disciplinary action is necessary due to misconduct or non-compliance, having accurate and accessible records of an employee's training history can significantly increase your case. So by providing clear evidence that an employee has been trained on specific policies and procedures, and they've also acknowledged their understanding and commitment to comply with them, you can reduce the legal risks associated with disciplinary actions. So, at PlutoLMS, we really want to focus on this data-driven approach that not only supports fair and consistent decision-making, but also helps demonstrate due diligence in enforcing compliance within your organization. Next slide, Nika. Automated processes. So our platform offers automation capabilities that significantly reduce the manual workload associated with compliance training. You can set up automated calendar entries, for example, and notifications to remind users when training is due, overdue, or needs to be refreshed. This ensures timely completion and adherence to compliance timelines. Automation capabilities also add substantial value by streamlining tedious administrative tasks and freeing up valuable time and resources that can be allocated to other strategic initiatives. It not only enhances efficiency, but it also minimizes the risk of human error and oversight, ensuring that no employee falls through the cracks when it comes to compliance training. Next slide. Big thing, changing perceptions of compliance training. It's essential, and we believe at Pluto, it's essential to change the negative perceptions around compliance training. Compliance shouldn't really be seen as a tedious obligation, but rather as a critical component to your organization's success and reputation. PlutoLMS offers innovative features such as gamification, badges, and certificates to make compliance training more engaging and rewarding for employees. So we're incorporating elements such as leaderboards and virtual rewards that make learning more interactive and enjoyable. These gamified elements motivate employees to actively participate in training activities and compete with colleagues in a friendly manner, of course. Moreover, rewarding employees with badges and certificates for completing training modules also serves as tangible recognition of their efforts towards making your company a positive and safe place to work. This approach not only enhances engagement, but also demonstrates the value of compliance training to employees and contributes by creating a positive and proactive compliance culture, ultimately strengthening the organization's overall compliance posture. So to close off, in summary, PlutoLMS can transform your compliance training initiative from a box-checking exercise into a strategic asset that boosts your bottom line. Maintain compliance and engage employees. Our platform offers a comprehensive solution for delivering, monitoring, and managing compliance training, helping you reduce risk and build a safer, more compliant workplace. Thank you.
Thank you so much, Ian. It's so lovely to understand how, the insights that Sarah has shared also link to technology and tools that there are tools out there that can really help us streamline the implementation of those strategies. So thank you so much for sharing your insights on how Pluto can do just that. And we will move over to our question and answer session now. So if anyone has any questions, please feel free to post them in the chat, and then we will facilitate this discussion from there. I would like to mention that if anyone does need to run, there is also a form pinned in the chat that you can access. You can access the link, and if you would like to get into contact with anyone from PlutoLMS or with Sarah, you're welcome to fill in that form and someone will get back to you soon. So there is also that option.
If anyone has any interesting HR stories, I also would love to hear them.
Yes. So we'll give 3 to 4 minutes for questions to come up, and then if no questions come up, we also realize it's Friday. Looming weekends might be more interesting at this stage than labor legislation. So
I have a question.
Brilliant, thank you. Go ahead.
So we have been struggling a lot. So I'm the HR manager at Library Wine Estate in Paul. So we work with various different personalities, various different outlets, from waiters to accountants. So we've really been struggling with employees reporting for duty while under the influence of alcohol. And I have given them a leniency of 0.05, just based on what the traffic leniency is. So one of my bar staff actually has, obviously he has a drinking problem, but we're sending him for a rehab now, an outpatient program. My question is now, he's going to have to do a 14-step program, and he has to complete it, and he's very keen to do it. But if he comes back and he, it goes well for a month or two, and he, goes back to old ways, do you then send him again? Or is it like final straw? What is your feeling on that? Because obviously it's an addiction, and he is trying to get help. I have dismissed multiple of them due to this and not wanting to get help. So for him to actually say, look, I'm struggling, I need help, but just the boundary on that, if he does, default or whatever the word is.
So this is actually a perfect question to what we were discussing. Nika, can you please go back to that slide where it was the 3 columns, the misconduct and capacity? Thank you. So Celine, you're also very busy if you're dealing with all of that. Okay. So with this is a perfect example. We've got an employee in the incapacity section here. Remember, if you think of it like a flow chart, you've got incapacity, ill health. You're sitting in the ill health section right now. You have done the right thing, given the employee the opportunity to get better by following an incapacity process. And just a note on that, remember, you don't, unless you've got something in your policies that says they will receive payment. If an employee is on incapacity while they are at rehab, they don't actually need to be paid during that time. So no work, no pay, and then they would pay them from UIF. So your question, I'm getting some feedback. Should I just mute? Yeah, I also got feedback. Okay, there we go. Is that better? Okay, cool.
Yeah, that's good.
Okay, so now this employee is in rehab, and your question is, he then comes back. He then says, I've improved, and then 2 months later. Yeah. So
Relapse.
I've actually, again, very sad, done a lot of incapacities on this where the employee is fine. But what you need to do in that recommendation or outcome, put it in writing that the employee will undergo tests. So breathalyzers and all of that for the next few months.
We do that every morning with all of the staff.
Okay. But if the employee now tests is positive or over the influence or under the influence, then you would then go into your column of misconduct. Because now I've given this employee the chance. You've been clear. It's a zero tolerance approach, or 0.5, or that's our company policy. It's in writing. You're aware of it. But we've given you the opportunity. But unfortunately, I cannot have people under the influence serving our customers. As long as we've got that clear to say and make it unambiguous, give me a call. I'll help you. We can write it together to say, if you then are found to be under the influence again, you will then go into a disciplinary hearing being under the influence. Okay. Long story short, we'll jump into your misconduct column.
Okay. Well, thank you. That helps a lot. That really does help.
Still not nice though.
No, but needs to be done.
Yeah.
At least he's going for help, so that's a good thing.
Yeah. Any other questions?
Hi there, Rudy here from Fairland.
Hello.
I've got two questions.
Yes.
One is a practical, one is more of a philosophical one. The practical is a worker drinks BioPlus. He needs to go in on a Sunday morning very early, drinks 2 packets of BioPlus, contains alcohol. The company has a zero tolerance alcohol policy. They do a breathalyzer on him, and then they ultimately dismiss him because he had alcohol in his blood. What do you do in that situation?
That's a tricky one. That concerns me, how that BioPlus has alcohol in it, because I have a lot of BioPlus. So Celine, just take note of that, maybe.
I can assist actually with that question.
Great, love it.
So let me just do this. So I did training for the breathalyzers. So regarding the BioPlus, it takes 20 to 30 minutes for it to actually be to not be in your system anymore. So they have to do 2 tests. The first test will indicate over the limit, and the second test cannot be done prior to half an hour. So let's say give it 30 to 45 minutes, and then that will be a clear indication, and he won't be over the limit anymore, because the test is actually in your saliva and obviously not in your blood. But in the case of if it hasn't fallen, below as much as it had as 0.00, I'm taking it as a zero tolerance, then the employee should go for blood tests. But with the BioPlus, we also had those incidents that they used that as an excuse. So it always has to be 2 to 3 tests conducted, and it will show how the alcohol goes down.
Okay. Did you just say that a breathalyzer works on your saliva?
Yes.
I've got police officers that say differently.
Well, that's a training I received with our breathalyzer guy. So he indicated to us. Yeah, he indicated to us with what is in your mouth.
I need your name and number, because I'm going to phone you the next time that a police officer pulls me over at a roadblock.
Perfect. No, really. It really is. I even have a certificate, so it's fun. I'll show them.
All right, my next question is that, okay, so we have got all these rules and regulations, and it's all utopian. But what do you do when a employee is in a position that he knows his boss is contravening the rules, etc., etc. And he technically can take his boss on, but he will most likely only get 3 months' salary. But he cannot afford to sit without a salary pending the CCMA resolution of the case or whatever other resolution can. He's going to go down sometime, somewhere. What do you do then? How do you navigate that labyrinth between the economically stronger party and the socioeconomically weaker party?
I'm thinking of all these good ideas for our next webinar, Mika and Ian, as we're talking. Just quickly before I answer that question, on Celine, your answer, that's great. And remember, you also have the observation test as well that you would use. So you'd also have that checklist. So you'd also have that if someone had BioPlus. Okay, to move on to the next one. Such a tricky question, because I often get, when I do implementations or give training with employees, I always say, okay, don't do this. Obey your employer. Don't swear at your employer. Don't try and give your employer a warning. And then they ask me the question, well, what happens if the employer is swearing at me, is not adhering to the terms and conditions we agreed upon? And again, it is so tricky. It depends on what it is. Remember, you could lodge a criminal case. Hopefully it isn't, that sense, but it could be. But the only real option an employee has is, and again, this is where I guess the balance comes in, is to lodge a grievance. And if that grievance isn't resolved, you then go to the next level of management and lodge a grievance again, and then go all the way to the CEO. And at that point, if there's still nothing done, that's when you would then refer your constructive dismissal. But to your point, and I think we'll have another webinar to have a debate on this, but what do they do in the meantime? Because you have to then resign, you would have to resign, and then you're also not getting paid. So very tricky. But from an employee perspective, it is tricky. Your only option really at that point is to lodge a criminal case, or you'll take civil proceedings and follow civil proceedings, or lodge a grievance. I wish I had a more clearer answer.
No, that was perfect. Thank you.
Those are good questions.
Thanks.
Thanks.
Thank you, Sarah. Thank you, everyone, for asking very, very good, insightful questions, and for the answers from the audience, Celine. I think it's 5-1 now, so we will call it a day. I just wanted to remind everyone, thank everyone for joining us. We really appreciate your time, and we hope we'll see you in the future. As Sarah has mentioned, we have many ideas for many more webinars, and we'd love to hear from you as well. Like I mentioned in the beginning, if there are any topics you'd be interested in, we'd love to incorporate those in our plans. And then if you would like to get into contact with Sarah or PlutoLMS to help you with compliance training or with your labor relations and HR management issues, please feel free to fill in the form at the link. The link is also pinned in the chat, or you can scan the QR code on the screen and you can fill in that form, and someone from either Sarah or from PlutoLMS will contact you soon. And then finally, I just wanted to remind you that you can keep your eyes out for an email after the webinar. We will be sharing the slides and Sarah's guide on preparing for a disciplinary hearing. Thank you so much, everyone. That's it from us.
Bye-bye. Thank you. Bye.
Thanks, everybody.
Thanks so much, everyone. Thank you.
Thank you.